On the 15th of March 2004, it was provided for as follows. The President, in accordance with this Constitution, shall appoint and may dismiss A, the Cabinet consisting of 1, the Prime Minister, 2, the 2 Deputy Prime Ministers nominated by the Prime Minister, 3, not less than 15 and not more than 20 ministers nominated by the Prime Minister, and then B, not less than 15 and not more than 20 deputy ministers nominated by the Prime Minister. The number of assistant ministers in the proposed constitution thus matched that of the ministers. Mutembei in the Okia case had also the following to say of that subject, and I shall not read it. The final report of the Committee of Experts, dated the 11th of October 2010, notes that Kenyans wanted, and I quote, that there be a clear distinction between offices of state and offices of government, unquote. Following public debates, the position of the assistant minister was abolished altogether and did not make it to the Constitution of Kenya 2010. It is thus not surprising that the size of the cabinet secretaries is now capped at 22. Article 152 of the Constitution provides that the cabinet shall comprise of A, the President, B, the Deputy President, C, the Attorney General, and D, not fewer than 14 and not more than 22 cabinet secretaries. It is therefore our considered view that the creation of a similar office to the assistant minister, now in name of CASs, cannot be created in the manner the first respondent and the fifth respondent proceeded. Based on the reasoning set out above, we do not think that it was the intention of the framers of the Constitution to have 50 CASs deputizing 22 cabinet secretaries. Furthermore, public participation on the office of CAS was founded on a complement of 23 CASs. Doubt is erased by the following other facts. In the letter of 11th October 2022 by Dr. Joseph Kenywa, Head of Public Service, to the PSC, the Head of State requested the PSC to declare 23 vacancies for CASs. We note, however, that the special issue of Kenya Gazette Notice number 12432, dated 12th of October 2022, and the media advertisement the following day calling for applications from suitable candidates did not set the number of vacancies. Furthermore, the stay in the Court of Appeal preserved the original office created on 24th January 2018. Once that office was abolished on 21st September 2022, the newly created office and complement of 23 office holders could no longer benefit from that stay. Accordingly, the newly created office and fresh complement of 50 had to comply with the Constitution and the criteria set out earlier in Okia's case in order to be lawfully established. They did not comply. For the avoidance of doubt, the entire complement of 50 CASs is therefore unconstitutional. I'll now ask my learned sister, Lady Justice Ongudi, to deal with the next issue.
So the next issue is on the financial implications of the creation of this office and whether the same is a waste of public funds contrary to Article 10 of the Constitution. We have already considered the submissions of the first and fourth petitioners on this issue as set out above, as well as the responses by the second and fourth respondents and the first interested party. We take note of the first petitioner's argument that the advice given by the fourth respondent to the fifth respondent in respect of the remuneration and benefits for persons appointed to the office of CAS was inaccurate and misleading. This was due to lack of information as to how many positions would be created. On the other hand, the fourth petitioner argued that the appointment of CAS is a waste of public funds and resources in the face of the high unemployment levels and economic recession facing Kenyans, that the payment of such salaries ran counter to the provisions of Article 10 of the Constitution with specific regard to public funds, resources, good governance, transparency, accountability, and sustainable development. The first petitioner argued that the fourth respondent did not give advice on the financial implications in creating the office with a complement of 50. The fourth respondent therefore failed to exercise its exclusive constitutional mandate under Article 230 4A. Further, that the fourth respondent, in its letter dated 14th March 2023, had advised for a higher gross monthly salary to that of the PS with no justification, as is clear from the Kenya Gazette Notice number 8792 of 2022. The second respondent submitted that the legislature has the power over public finance and the independent offices of the control of budget and the Auditor General to report to it. These are the offices that should determine the issue of wasteful spending. The fourth respondent submitted that the advice by the fourth respondent on remuneration and benefits for the CS was issued within their constitutional mandate under Article 230, Subarticle 4B of the Constitution and Section 11 of the SRC Act and not the SRC Regulations 2013. The advice was thus based on an objective and fair process which took into account the principles outlined in Article 230, Subarticle 5 of the Constitution and the job descriptions by the fifth respondent. The first interested party submitted that under Article 228, 4 and 5 of the Constitution, it was not responsible for paying remuneration and benefits to the CSS or any other state or public officers following their mandates under Article 228 of the Constitution. We also note that the initial CAS office, as established in 2018, was graded under Job Group U, and the appointed persons were to enter at the midpoint of the salary scale. After this office was abolished and a new one established on 11th of October 2022, the position was graded under Job Group CSG3 in the public service. The gross salary is above 700,000 shillings plus other emoluments as seen from the letter from the fourth respondent. The second respondent, with reference to the 27 additional CSS, made known that their financial provision was given the green light by the National Treasury, which indicated that there was sufficient funds to cater for the additional numbers. We referred to Article 230, Subarticle 4 of the Constitution, which provides for the powers and functions of the SRC. Further to the above, Rima J in the Okia case found that failure to involve the fourth respondent on the financial matters of the CS office was a serious omission, rendering the establishment of the said office unconstitutional. It is therefore clear to us that the fifth respondent should have consulted the SRC in order for it to ascertain the resultant financial implications. A related issue arising within the context of the various financial implications is the question of whether this court can make a decision on budgetary issues. The court in the case of Wanjiru, Gikonyo and two others, expounding on this issue, opined as follows. By justiciability, it is meant a matter proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision. A court must satisfy itself that the case before it is not caught up by the bar on non-justiciability. The concept is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. It is our considered view that based on the separation of powers doctrine, budgetary concerns fall within the realm of policy and rightly belong to the other relevant arms of government as may be appropriate. We thus decline the invitation to delve any deeper into that arena.
I'll now ask my honored brother, Justice Alem Fisram, to deal with the next issue.
The next issue is, was the President improperly enjoined as a party to the proceedings? The second to the fifth respondent submitted that the first respondent was improperly enjoined the present consolidated petition. The petitioners on their part did not oppose the said prayer, but contended that the misjoinder was not fatal to the consolidated petition. Having considered the submissions of the parties on this issue as set out above, we are guided by Article 143 of the Constitution and the decision of the Supreme Court in, and I will not read the full citation, but more commonly known as the BBI case, where the following paragraphs the court stated as follows, and here I will only quote the relevant paragraphs because we have quite a long quote. Anybody or any party aggrieved by the President's actions or failures can initiate proceedings against the Attorney General, who by virtue of being a legal representative of the government in legal proceedings also represents the President, who is the head of government. The immunity, on the other hand, offers protection that shields the President from civil suits being filed against them in their personal capacity. I will further quote, as such, pursuant to Article 156(4) of the Constitution, the exercise of public power by the President can be challenged in the court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein the court may issue appropriate reliefs. This leads me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that civil proceedings can be instituted against the President or the person performing the functions of the office of President during their tenure of office in respect of anything done or not done contrary to the Constitution. Pursuant to Article 143 of the Constitution and based on the law as set out above, we find that the first respondent was improperly enjoined to the consolidated petition. We further find that the misjoinder is not fatal to the consolidated petition, but take the opportunity to urge the petitioners and future litigants to avoid this practice in light of the unequivocal pronouncement by the Supreme Court on this issue.
Thank you. I'll now ask the Honorable Lady Justice Hedwig Ngudi to deal with the next issue.
The next issue is whether the consolidated petition was drawn with sufficient precision. In a constitutional suit, a party that alleges violation of his or her rights must plead with reasonable precision the manner in which the rights have been violated. We have a number of authorities on this. And our interpretation of the above provision is that for a constitutional petition to be sustainable, it must satisfy the thresholds